Supreme Court rules action of Tamil Nadu Governor R.N. Ravi referring 10 bills passed by the Assembly to President as illegal. Supreme Court holds that the Tamil Nadu Governor's reservation of 10 bills for President's assent is illegal and liable to be set aside. The following timelines are being prescribed and failure to adhere to this time will invite judicial scrutiny. Number 1 being in case of withholding assent and reserving it for President with aid and advice of Council of Ministers, maximum 1 month. Withholding assent without aid and advice of Council of Ministers, a bill to returned within 3 months. Bill to be returned within 3 months. There in case of presentation of bill number 3. After reconsideration by State Assembly, the bills to be assented by the Governor within 1 month. Any exercise of discretion by Governor under Article 200 is there in fact amenable to judicial review. We do not agree with D.K. Pavitra that Constitution gives discretion to Governor in matters of reserving bills for President under Article 200, noted the top court. Let's quickly go across to my colleague Gautam Shankar, who joins us live from Bengaluru on more on this. Gautam, do give us all the details regarding this particular, ruling by the Supreme Court. The Supreme Court, in fact, there has ruled action of Tamil Nadu Governor R.N. Ravi, referring 10 bills passed by the Assembly to President as illegal.
Yes, Neha, a big verdict coming from the Supreme Court here. And this verdict basically could set a constitutional precedent in terms of governor-state relationships that are evident across India as well. Now, the Supreme Court, like you rightly pointed out, it has framed a timeline for the governors to decide on bills that have been passed by the state assemblies. Now, the Supreme Court has mandated that governors should decide on referring bills to President as per the advice of the Council of Ministers within 1 month. So within a matter of 1 month, the governors need to decide on whether this bill needs to go to the President or not. And the other important factor being that the governors should decide on withholding assent on the bill passed by the assemblies within 3 months. So they cannot sit on it indefinitely, which has been the complaint by the DMK government in Tamil Nadu as well. And the Supreme Court has also ruled the action of Tamil Nadu Governor R.N. Ravi, his actions of referring these 10 bills that were passed by the assembly as illegal, to say that he passed these bills to the president, that the manner in which it has been done, the Supreme Court has noted this as erroneous and illegal. So this is a big verdict that has come in from the Supreme Court. And basically now what this means is the governor in not just Tamil Nadu, across India, will not just be able to sit on the bills and they cannot set it aside. There is a time frame that has been given within which they need to decide whether it needs to go to the President of India, or whether it needs to, if he's going to withhold the assent, then that can happen only within a matter of 3 months as well. And keep in mind, the whole issue came into light after DMK had moved the Supreme Court seeking directions against the governor to decide on the assent given to bills by the state legislature in a time-bound manner. And the state government had also argued that Governor R.N. Ravi was indefinitely withholding assent on these bills. And by doing so, he was withholding the entire state to ransom, is what the arguments that were made in the court as well. And in such a situation, they had said that the Supreme Court must intervene. And now we have seen a big verdict coming from Supreme Court here in this matter.
Continue to stay with us, Gautam. I'm also joined by Satish Kumar, advocate, Madras High Court. A very warm welcome to you, Mr. Kumar. Do tell us, what does this Supreme Court ruling really mean for the role of governors across states going forward?
Really, to say it is a little bit surprising for me, because from the constitution angle, the Supreme Court has given a verdict, especially on Article 200. According to my understanding, unless otherwise the full judgment comes out, whether it is a procedural aspect, it has been shown as illegal, or from the point of the constitution, it is shown as illegal. So there are two ways of analyzing and or seeing the perusing the judgment. So I feel that in this case, it might be based on the procedural aspects and not on the constitutional aspect, because the rights of the governor is clearly stated in Article 200 that there are four ways of which he can give the assent to the bill, or he can return the bill, or he can refer the bill to the president. But in this case, especially on this 10 bills issue, we have to go through the judgment in full by seeing whether in what date he has kept the bill and what date is got returned, and all these date-wise things has to be seen. That's what I personally feel. Unless otherwise the judgment comes in full, we cannot jump into conclusion that the governor is totally wrong in this aspect.
Right, continue to stay with us, Mr. Kumar. In fact, I also have my colleague Gautam Shankar with us. Gautam, quickly coming to you, do tell us, has there been any immediate reaction from the Tamil Nadu government or political leaders or the governor himself?
Not yet, but we can expect stinging reply coming in from the DMK government, especially M.K. Stalin, who has been at crossroads with the governor over multiple issues. And the most biggest issue has been that the governor has been sitting on bills and not passing them as well. Now, one particular aspect that the Supreme Court has made, there's this aspect I just want to highlight here as well. The Supreme Court has noted that there is no room for pocket veto or absolute veto in the constitution. There is no scope for inaction by the governor. The governor has to adopt one of the three options under Article 200. It has been adopted with a sense of expediency, and it cannot sit over the decision, is what it says. And also, it further goes on to say that the reservation of the 10 bills by the governor for the consideration of the president is illegal and erroneous in law as well, which basically signifies that there was no real scope for the governor to be passing these bills on to the president itself. And the Supreme Court itself saying that the way Governor Ravi acted in this matter is illegal and erroneous will come as a big victory for the DMK government. And it will be interesting to see how they are going to respond to this matter. And they will claim this as a moral victory in the state of Tamil Nadu.
Right, very quickly, Gautam, I'll take one more question from you before I go to Mr. Kumar. Do you think that this is some sort of a warning shot to governors across India?
Yes, we can take to some extent the view that I cannot say
Mr. Kumar, I'll come to you. Mr. Kumar, I'll come to you. This question was for Gautam. I'll just come to you in a second. I have other questions for you. Just 1 second.
Yeah, Neha. So, yes, this is going to have a constitutional precedent across the nation, because keep in mind that while the Tamil Nadu government went to Supreme Court arguing that the governor's actions violated the constitution, the kind of statements or the observations that were made by the Supreme Court before this verdict came out, that was quite interesting as well, because one key observation that I remember is that Supreme Court saying that the Tamil Nadu Assembly had repassed several bills after they were returned by the governor, and then it had questioned how then could the governor send them to the president, and is this legally permissible? Is the question that Supreme Court had asked itself. And based on this, after gathering several statements, now the Supreme Court has basically ruled that the manner in which Governor Ravi has acted is unconstitutional, and basically saying that his actions were erroneous and illegal as well. Now, Tamil Nadu government had raised several other issues as well, because not just about the governor's actions being in violation of the constitution, they had cited several examples that a bill was passed in the assembly, given to the governor. He sat on it. They thought, okay, he's asking for corrections. Then they passed this bill again in the assembly after a few days, and yet this bill, without even getting a look from the governor, was immediately passed on to the president. So this kind of actions by the governor is something that we may not see in the future, and that is the kind of precedence the Supreme Court ruling sets here.
Right. Gautam, continue to stay with us. Mr. Kumar, coming to you, the judgment, like my colleague Gautam said, the judgment says the governor cannot sit over the bill. Does this end the practice of indefinite delay by the governors?
Now, only I am observing from your caption that a time limit has been set by the Supreme Court in this case especially. I want to see whether the time limit set for this case, or there is an observation or finding, or maybe because Article 200 does not say about the time limit up to what time it can be kept pending, because now this is a new rule set by the Supreme Court, and that may be a precedent for the subsequent cases, because Article 200 so far does not say about the time limit. Now the Supreme Court has set a time limit. In this case, it requires an amendment in the Constitution also. That's what I personally feel. So unless the Constitution is getting amended, especially on the time limit aspect, at present, though the action of the governor has been said that it is illegal as of today, if the time limit is set, then we cannot say in the subsequent cases but the time limit has to be followed. In case it is not followed, then it can be said illegal. But in this case, presuming that it is an illegal because of an unlimited, without giving any response, or for unlimited time, the governor has taken his own time for keeping the bill pending. That may be called as an erroneous on his part, but we cannot say this is a very big victory for Tamil Nadu government. That's what I personally feel. But it is a good advice, or maybe even to the parliament, to amend the constitution, Article 200 in this aspect, especially because most of the states are facing the same problem, maybe to some extent by questioning the governor in this aspect. But I welcome the even in the previous programs also, I very well stated that it requires a time limit for which amendment is required in the Article 200. Now the Supreme Court has now I'm saying from your caption, I'm seeing that it has fixed a time limit. If the time limit is set, then it requires an amendment in the Constitution also.